Bienvenidos y welcome everybody to our first Memoria Talk. We are thrilled to have you with us this morning if you are joining us from Latin America, or afternoon if you are in Europe. Let me briefly introduce myself to you. My name is Boris Burkhardt. I'm a professor of criminal law, legal philosophy, and contemporary legal history at Philipps Universität Marburg. And I'm also one of the members of the Memoria-Legal Expert Group, and as such, one of the conveners of this event. Dorothee Weidbrecht will explain to you the idea and aims of our expert group in more detail in a minute. Our event today is dedicated to the 20th anniversary of the issuance of arrest warrants of the Nuremberg Criminal Court of First Instance against Jorge Videla, Emilio Massera, and Carlos Suarez Mason. And as you have seen in the program, we have structured our talk into two sessions. First, a session looking back on the efforts that led to the issuance of arrest warrants, and a second session to discuss more recent developments and to take stock of the importance of these efforts from today's perspective and looking forward. Before we start, a quick note. First of all, I want to apologize on the part of the organizers for our slight delay. Of course, you prepare an event like this, and then at last minute, everything changes, technical problems appear. We had to make arrangements because some of our speakers couldn't make it, unfortunately. Our chairs will explain the changes we have made to you a little bit later. We have asked the panelists to give short impulses of 10 minutes. We will then have enough time to discuss, and you are invited to direct questions to the panelists. Please do so by writing into the chat during the presentations, and in our Q&A following both sessions, the moderator of each session will then bring your questions into our discussion. Now, as you may have noticed, we have named this event the first Memoria Talk, indicating that we hope this to be the first of many following. Our symposium today does also have the purpose to launch, so to speak, public activities of our Memoria Legal Expert Group. Dorothee will now explain to you who we are and what the aims of our working group intend to be. So let me briefly introduce Dorothee to you. Dorothee Weidbrecht holds a PhD in history and is an expert of memory culture and international conflict studies. Even more importantly, she is the founder and executive director of the Elisabeth Käsemann Foundation. And in this function, she is the heart and soul of the Memoria Legal Expert Group and thus of our event today. So please, Dorothee, the floor is yours. Microphone. Dorothee, we still can't hear you.
Yeah.
Now,
of course, that's always happens. Thank you very much for your nice words, nice introduction, Boris. Dear speakers, dear ladies and gentlemen, I would like to welcome you to the opening event of the Memoria Talks series organized by the German-Argentine Legal Working Group, Memoria of the Elisabeth Käsemann Foundation. Before I turn to the founding context and the objectives of the working group, I will give a brief history of the criminal law on crimes against humanity in Argentina and Germany and the situation today. From 1976 to 1983, the civil-military dictatorship in Argentina committed the most serious human rights violations with systematic torture, killings, disappearances, and child abduction in order to destroy the political opposition and dissidents. The Argentine state and its committed civil society are now among the world's pioneers in coming to terms with dictatorial past. Since the Argentine impunity laws of 1986, and 1987 were repealed in 2003, crimes against humanity committed during the dictatorship have been consistently investigated and prosecuted by the judiciary. National Socialist Germany attempted to exterminate the Jewish people in Europe and other victim groups from 1933 to 1945, with enormous logistical effort and the use of industrial killing methods on an unprecedented scale. Its history has forced the country to face up to its past and its responsibility in order to be recognized as a democracy in the international community and to function as a democracy again. Germany will still has the task of analyzing historical authoritarian and anti-democratic structures and preventing trends in this direction. For decades, Germany remained lenient in the prosecution of National Socialist perpetrators. It was not until 2011, with the trial of John Demjanjuk, who was an SS guard at the Sobibor extermination camp, that the usual, with a few exceptions, legal practice in Germany changed. In the years since the judiciary in both Argentina and Germany began to face up its past, criminal law on crimes against humanity has developed into a key international legal instrument. Since the end of the last century, responsibility for the prosecution of crimes against humanity has not only rested with the countries from which the perpetrators and victims originate. Since the institutional establishment of international criminal jurisdiction and the growing importance of international criminal law in many countries, it has become a fact that under certain circumstances, these crimes fall not within the jurisdiction of national justice systems, but also within that of the international community and its individual states. Now I continue with the founding and projecting Memoria-Legal Working Group. The impulse to establish a German-Argentine working group on international criminal law came from the fourth symposium of the Elisabeth Käsemann Foundation, which was organized in cooperation with the Faculty of Law of the University of Buenos Aires. For 2 days in September 2019, German and Argentine experts in particular discussed the opportunities and limitations of a society-wide approach to dealing with autocratic pasts or violent conflicts, such as truth commissions and peace process, in comparison to traditional criminal prosecution. Based on this fruitful academic exchange, the idea was born to establish an Argentine-German working group on international criminal law. The Argentine lawyers Natalia Barbero, Alberto Suppi, and Silvina Alonso were able to gain high-profile German partners for the working group in Stefanie Bock, Boris Burkhardt, and Julia Genols. Long-term plans of the group include publications, the stimulation of new scientific projects, the organization of and participation in national and international conferences, and university events for experts and students. The aim of the group is to promote a professional dialogue on issues relating to the enforcement of international criminal law in order to deepen German-Argentine academic relations and strengthen democratic values and human rights. The binational working group focuses on various issues relating to international criminal law and related interdisciplinary topics such as genocide as a legal concept, laws on the denial of crimes against humanity, legal cooperation between Argentina and Germany, international crimes in national legislation, and gender issues in the prosecution of international crimes. However, topics relating to the history of justice, the autocratic past, and its legal processing in Germany and Argentina are also part of the debates, which is where the name Memoria comes from. For example, forms of transitional justice, exchange on the standards and instruments of condemning crimes against humanity in the Argentine and German past, German victims of the dictatorship in Argentina, and on the other side, Argentine victims of the National Socialist dictatorship, trials for international crimes in Argentina and Germany, and reparation for the victims. As the first joint project of the working group, the Memoria Talks series was launched as an academic event to draw the attention of experts and students to current and interesting issues in the field of international criminal prosecution and to discuss them with them. Our inaugural event is dedicated to a historical topic, its impact and its current relevance. It is 20 years ago tomorrow that the Nuremberg Public Prosecutor's Office issued an international arrest warrant against former foreign leaders for the first time in the history of the Federal Republic of Germany. On November 28, 2003, the German judiciary applied for the extradition of the military junta that ruled Argentina during the first years of the dictatorship, including the former de facto president Jorge Videla. This opened a new chapter in the international prosecution of crimes against humanity in Germany. Our speakers, Stefan Herbst, Wolfgang Karlek, Alberto Zuppi, Federico Efron, we hope he can make it, and Julia Genos will now explain how this historic decision in German history came about and what the relevance it has for subsequent proceedings. We wish you all a lot of interesting insights and look forward to your questions after every panel. And now I wish to hand over.
Thank you,
Stephanie, or first Boris.
Yes, I will take over for some more minutes. Thank you, Dorothy. And as I've mentioned before, our first panel intends to take a look backwards on what was achieved 20 years ago. Our chair for the first panel is Natalia Barbero, who has already been mentioned as one of the members of our group, and which I now have the pleasure to introduce to you with two more sentences at least. Natalia is a professor of criminal law, international criminal law, and international human rights law at the University of Buenos Aires. She's also, as mentioned, a member of our group, and she currently is a fellow of the Alexander von Humboldt Stiftung at the Goethe-Universität in Frankfurt. So she just told us that she's going back and forth between Argentina and Germany. Yeah, Natalia, please, the floor is yours.
Thank you very much, Boris. Thank you, Dorothy. Welcome, everybody. We are very happy, very glad to host this event today, and we appreciate every participation, the speakers, the audience. We are very glad to start this first Memoria Talk. And first of all, I would like to say that we have a slight change in the first panel. We had the program published with 3 speakers. We will have 2, unfortunately. One of them, Rodolfo Janson, will not be able to be here with us today. So we will have 2 speakers, and we would start now with the first of them, Stefan Herbst, who is right there. We can see him. Welcome, Stefan. Stefan was co-founder of the Nuremberg Human Rights Center. He experienced genocide in Guatemala in 1982, 1983 as a student of theology at the University in Mexico, Iberoamericana University of Mexico. He participated in meetings of the HRC in Geneva denouncing human rights violations in Colombia and Argentina. And from 1998 to 2004, he served as one of the speakers of the German Coalition Against Impunity in Argentina. He's working as a lay minister in Biel, being a Peterland in Switzerland, responsible for the social working of Catholic Church. He will talk today about the work of the Koalition gegen Straflosigkeit in Germany until the issuance of the arrest warrant against Jorge Videla. Please, Stefan.
Yes, hello. Good morning and good afternoon to everybody. I only will speak until the year of 2003. The work of the Coalition Against Impunity was some years longer, but okay, I will only speak until only about the first 5 years of our Coalition Against Impunity. The Coalition Against Impunity was officially founded in 1998. The coalition at that time was a gathering of different groups which worked together with the same aim, the end of impunity in Argentina. Integrants of this coalition were first groups of Germans having personal experiences and personal relations with Argentina. They were strongly committed to solidarity with victims of Argentine repression. These were people with very different backgrounds, but all working together in some kind of solidarity. The second branch of the coalition were classical human rights institutions, as for example, Amnesty International. In Amnesty International Germany existed groups who had worked on Argentina during military dictatorship. Some of these persons joined the coalition. The other very important group was the Nürnberger Menschenrechtszentrum. The third branch of the coalition were ecclesiastical actors like the Human Rights Department of Diakonische Werk from the Protestant Church. And here you have the former representative of Missionszentrale der Franziskaner, Mission Central of Franciscans, which had its base in Bonn and worked together with Franciscan sisters and brothers all over the world. This coalition of different actors found together and was animated for its work by some important human rights organizations of Argentina. In concrete, it was Peace Nobel Prize laureate Adolfo Pérez Esquivel who asked German groups, especially the Nürnberger Menschenrechtszentrum, which has worked on Latin America, to work now on Argentina, against impunity in Argentina. The executive secretary of the Nürnberger Menschenrechtszentrum at that time was the Peruvian human rights activist Esteban Cuya, who became at the time also one of the pillars of this movement. He and Kuno Haug, me, Stefan Herbst, and at the very beginning, the staff members of Diakonische Werk, Christiane Schulz, were at that time professionals working on full time for institutions and being able to use institutional resources for this kind of lobby and pressure group. These movements and groups, we could reach a lot of political support first from the official churches of Germany, the Protestant Church EKD, and also Justice and Peace Commission of the Catholic Church. We informed and visited official representatives of Protestant and Catholic Church working together with governmental and political institutions in Germany. We also got support from political persons, especially in the Green Party and the Social Democrat Party of that time. One of the nearest parliamentarians of the time was the Green lawyer and member of parliament, Hans Christian Ströbele, who supported this work as a member of parliament. Other actors were in some kind Hertha Däubler-Melin, who came from Tübingen and knew therefore from first-hand what had happened to Elisabeth Käsemann. We got also help from people like Dorothee Sölle, one of the most famous Protestant theologians in her time. We also got a lot help from professional journalists like Osvaldo Bayer or Frieda Wagner, and last not least, Gabi Weber. I also would like to recall that we asked the Max Planck Institute on Criminal Law in Freiburg to give a scientific advice on these cases. This expert report was published in 1998, and the person who wrote it was at that time only 33 years old professional human rights scholar, Dr. Kai Ambos, who afterwards worked in the International Criminal Court and actually is Professor Dr. Honoris Causa, serving at Georg August University Göttingen. At the time, 1998, we still were in the aftermath of the collapse of the bipolar world between communist East and capitalist West, and also with a strong movement of non-aligned states. We were 14 years after the end of military dictatorship in Argentina. I can make it a little bit shorter. Yes, at that time, 1998, it was a time when still a great number of persons, especially in military structures in Argentina, who had taken part in crimes against humanity and the crimes of enforced disappearances, were still in duty and living in impunity, although they had blood on their hands. In 1998, Osvaldo Bayer, a German-Argentine publisher, wrote in Página 12, "We have to get it clear that we live in a society which compares stable and bad with executioners. It is in this society when a Jesuit named Jorge Bergoglio was appointed 1998 as Bishop of Buenos Aires. He had served as a provincial for the Jesuits during military dictatorship, and at that time was accused of Jesuits working on the ground, on the base movement, for not standing up against military dictatorship. And that time, all possibilities in Argentina to find an end to impunity were in a dead-end street. Although the military government had to hand over power, it still had a lot of influence of politics and society of the country. I don't know. I think the most participants will know the situation of the time, that in the beginning, Raúl Alfonsín tried, or he made possible first trials, but afterwards he was under enormous pressure of military, so he pronounced the so-called full stop and due obedience laws, which prevented the prosecution of most of the criminals. And as it was President Menem who ordered the pardons of the formerly all persons which had participated, a pardon for all persons which had participated in the crimes of the military dictatorship. The German situation at this time in 1998, when in Argentina the fight was in a dead-end street, was contrary to this. In preparation of Bundestag elections in September 1998, especially Green Party and Social Democrats of that time had, together with PDS, the Socialist Party, a strong inclination to grassroots movements, as the human rights movement, the peace movement, and the ecology movement. The Social Democrats of that time had a strong left wing formed by persons like the party leader Oscar Lafontaine or the jurist Herder Teubler-Melin, who became after the election Ministry of Justice. It is in this year, 1998, when we organized our first hearing at the Wasserwerk Bonn, a great building in Bonn, which had been used from 1986 to 1992 as assembly hall of the German Bundestag. In preparation of this first hearing, we spoke and invited different members of German Bundestag and the Green fraction and the SPD fraction gave at that time some money to help finance this hearing. It was from great importance that at that time the Missionszentrale of Franciscans in Bonn, we had our office in Bonn, so Pérez Esquivel lived in our guest room, and we could use all the offices of Missionszentrale to gather and to prepare this important hearing. In preparation of that hearing, we gave to our lawyers the task to prepare charges against militaries for some important cases. The most important case was the enforced disappearance of Elisabeth Käsemann. Our most important lawyer at the time, at that very first time, was Tino Thun, an expert in criminal law. He worked together with his companion Roland Becker as lawyer. Tino Thun was an extraordinary lawyer for our cases because he had written his doctoral thesis on the military dictatorship in Argentina and the clandestine cooperation of German politics of that time. So he had a very, very big background of all what happened at that time. We decided at the time to make a new publishing effort of his book Menschenrecht in Außenpolitik from 1985. This book was newly published together with actualizations of Coalition Against Impunity in May 2006. If some of you would like to find it, you can find it for €4.16 as old books in old books in Germany. 2 months later, when this book was published, so it was published in May 2006, 2 months later, Tino died. At that time in 1998, he and others worked on the cases of Elisabeth Käsemann and Klaus Zieschank. Klaus Zieschank disappeared as a young student in 1976, and Elisabeth Käsemann, involved in clandestine work, helping opponents of the military regime to get out of the country, was disappeared in 1977. Elisabeth was the daughter of Professor Ernst Käsemann, a well-known university teacher of theology at his time. He had also a very strong reputation in Protestant church because he was one of the outspoken few Protestant theologians who, after first feeling sympathy for Hitler, became an opponent of Adolf Hitler and the Nazi regime. For every case, our lawyers would carry on. We needed the express will of the relatives, as every one of us knew that Elisabeth Käsemann was the most important case because of the work of her father in the former time when she was disappeared and had gained a lot of publicity at that time. We wanted to retake this case, which at the time German fiscals had closed at that time before. Saying that at the time they could not make any investigations because Argentina did not cooperate. It was in January 1998 when I wrote a letter to the family of Elisabeth Käsemann to ask for their allowance to take the case. 1 week after this, I called the family Käsemann. Then the mother of Elisabeth told me that Ernst Käsemann, her husband, was very ill and that I should wait for a visit. On 17th February 1998, Ernst Käsemann died. It was only after his death when I visited the family Käsemann, but Mrs. Käsemann told me that her husband was very, very excited and comforted by the message that the case of his daughter would be given another time to German justice. Now with a lot of help from different NGOs in Germany and as well in Argentina. It was in May 1998 when we had our hearing in Bonn. We used this hearing in Bonn to hand over the first charge against militaries and the junta chiefs to a representative of Ministry of Justice. We expressly asked at that time to decide that the case should be given to the public prosecutor's office in Nuremberg. We had in mind that the city of Nuremberg was a symbolic place as it became famous for the Nuremberg war crime trials against German Nazi leaders. Nuremberg was a symbolic town to strengthen international criminal law and the establishment of an international criminal court for crimes against humanity. On the other hand, Nuremberg became very important for our cases because it was the place where Kuno Haug from Protestant Church and member of Nuremberg Human Rights Center and Esteban Coya lived. Especially having these offices in Nuremberg, it was easy to find cooperation with the then appointed Nuremberg fiscals involved. We took care and it's too long.
Sorry. I'm so sorry to interrupt. We have exceeded our time. If you can sum up, and you can also answer questions at the end of the panel, please.
Okay. We had other meeting in another meeting in 2000 in Berlin when we at that time we were invited from the Buddhist president of Germany, and at that time we could meet the new appointed Ministry of Justice, Hedda Deublak-Melin, to give other hand over other charges. Also at that time, Wolfgang Kalek, who will now speak, joined us, or a little bit before, and he was also a very, very important jurist, and afterwards he made a career in all these issues. As I have read in the press, on 4th of December 2003, so we have a little bit a difference. I don't know exactly why. German prosecutor of Nuremberg filed an arrest warrant against junta members Videla, Massera, and Suarez Mason, army chief at that time. I would like also to stress that in 2001, we had a meeting on enforced disappearances in Geneva, in the Human Rights Commission in Geneva, working together with, I don't know, perhaps you will know him, Federico Andreo Guzman, a very prestigious lawyer, Colombian lawyer in all these affairs.
Thank you very much. Thank you very much, Mr. Herbst. We have now to hand over to Wolfgang Kalek, and we are looking forward for a discussion after the panel.
Thank you, Stefan. Now I would like to welcome Wolfgang Kalek. He founded the European Center for Constitutional and Human Rights with other international lawyers in Berlin in 2007, and he has served as the organization's general secretary since its foundation. And since 1998, he has been involved in the Coalition Against Impunity, which fights to hold Argentinian military officials accountable for the murder and disappearance of German citizens during the Argentine dictatorship. Please, Wolfgang.
Yeah, thank you very much, Natalia, and thank you very much to the organizers of this conference on this historical date. Yeah, actually, I'm more than 25 years in this work. The newly founded organization ECCHR is also part of the coalition. And by the way, the coalition has not been dissolved until today, because we always thought there might be an opportunity. And actually, I thought that until the very last week. And so, first of all, I have to tell you that I have difficulties to stay cool in this conference and to talk about legal details of whatever happened 25 or 20 or 15 years ago. First of all, because of the results of the elections, which not only bring the 40-year-old democracy in Argentina in danger, and many of you know much more than I about it, but also might bring a big risk to the ongoing investigation and prosecutions, and might even bring our friends and colleagues and the activists in Argentina in danger. There will be definitely cuts in the subsidies for all our colleagues whom we had been working now 25 years ago. So that's the one thing, and you have learned about it in the newspaper. The other thing is that until the very last week, we had been hoping that the work of the coalition, and in particular the work on the Keyboard case, will culminate in an oral trial next year at the Landgericht Berlin, Schwurgerichtskammer. And actually, I have here with me the 223 pages indictment against Mr. Keyburg, which bears a lot of potential to also for legal discussions, in particular when we see which problems we have been facing at the beginning 20 years ago with our work. And you know all that while the prosecutor's office, Generalstaatsanwalt Berlin, had already delivered this indictment to the Schwurgerichtskammer, to the chamber in Berlin. We learned last week that Mr. Keyburg died already in October. So here we have the indictment result of sorrowful investigations of the Berlin prosecutor and many years of our work. Obviously, it was even impossible to talk to those family members who committed themselves to be civil parties in this trial. They were incapable to talk about this because they had to digest what happened. So coming back to the coalition is actually when we see the many crimes, similar crimes in the world, which have been committed in the second half of the last century. In the beginning of this century, the coalition was actually the first civil society initiative of this kind, which dealt with international crimes and tried to bring them to court in Germany. And the interesting thing, and you might already hear that from the different voices of Stefan Herbst on one hand, myself, I saw also others like Kuno and Jan Dunkhorst from the Solidarity Center, FDCL. So very many different perspectives in one coalition. It was sometimes difficult, but it helped actually the cause a lot because as Stefan rightly pointed out, it was not only legal efforts we had to undertake, there were a lot of advocacy work, and it was absolutely helpful that we had church groups, some of them with access to not only the federal Minister of Justice, but also the province Minister of Justice in Bavaria, who was in a way crucial for the go or non-go of certain parts of the investigations. So we had been facing multiple challenges when we started these trials. It was not only the first civil society initiative, it was obviously the first time the prosecutor in Nuremberg was involved in such an investigation. They were the kind of crimes they had been dealing with is expressed by the thanks we received from the punks and the Kurds of Nuremberg, who said, now you employ the prosecutor with real crimes before they dealt with us. So they had, with small scale, so-called political crimes, no experience at all. And then we, over the years, filed on behalf of 40 victims, cases against 90 military. And they had to start to investigate the crimes of a faraway military dictatorship where they basically had no clue about. So the interesting thing is that they really committed after a while to these crimes, although we have to say we had this very crucial moment at the very beginning when they would call us after the first or the second of our complaints. They would call us and would say, now you had made a meeting in a public event in Bonn and another public event in Berlin, and that was covered by the media. And so that's actually what you wanted. Or do you want even more? So they were at the beginning not even aware that we meant it absolutely serious with our petitum to really investigate and prosecute. And so over the years, we had to really brief them on the facts, what happened in Argentina. And that was actually very well done by the aforementioned Esteban Cuya, who stayed with the Nürnberger Menschenrechtszentrum in Nuremberg, just basically next door to the prosecutor. And so he was able to explain over and over again, to translate, to select crucial documents on the facts. So that was an absolutely important work. So the second really big challenge was the bad law we had by that time. It was no prohibition of no criminal type of crimes against humanity, and also a very unperfect law, like many other laws of that time. So we had an ongoing discussion with our Argentinian colleagues, and in particular with the group of the human rights organization, who were not in accordance with us when we filed our complaints because of homicide. Homicide was the only crime which was not banned from statute of limitation. And so the Argentinian, and by the way, the indictment, the aforementioned indictment, contains homicide in 23 cases of disappeared. So that's what we had been dealing with this problem 25 years ago, and we had been dealing with this problem until now. So the prosecutors basically said there is no proof of death, and second, as there is no proof of death, there is no proof of how these people came to death. They could have died because of everything, and so we cannot prove that the military officers you directed your complaint against had the intention of homicide, the mens rea. And so that was the basis of our work. So we tried several things. One is in the German Jewish cases, which had another challenge, because many of those who disappeared were not German citizens, and so we had to argue that legally they should have been treated like German citizens, which at least brought us to the point that the prosecutor's office investigated their cases, but at some point they stalled the investigation before the release of arrest warrants, and would say we have no proof of the homicide. But at least, until that point, we could convince them. We tried together with our Argentinian colleagues to also bring a genocide case, because that's something, which was discussed by the time. You might remember the Spanish investigations in the Argentine, but also in the Chilean case. And so there was, and the basis of that prosecution was to argue that the political group has been persecuted, and therefore we can argue that it's genocide. We tried it knowing that in Germany the chances are very small, but we tried it also for the reason that we wanted to bring to a knowledge of a broader public how invalid the German law is. And by the way, the Argentinian cases served as an important material in the discussion of the 20-year-old Code Against International Crimes in Germany. So we had two sets of cases. One was the Serbian war crimes cases, and the other was the Argentinian cases. And not only good precedents serve as a basis for law reform, but also cases that failed for legal reasons. And so the cases were discussed. The genocide complaint failed. Also, our argument, referring to the efforts of especially the Chilean colleagues of ours, to argue that there is a continuing crime which has not ended the disappearances. So there is no statute of limitation applicable. That was also not subscribed by the Federal Prosecutor's Office. So at some point we saw that we could to get with the help of our advocacy efforts, we could convince the prosecutors to investigate up to a certain point, but it will be very difficult to argue further on from that in the case of the 40 victims. So we focused very much on the two cases where we had German victims, where the corpses were found, and that were the cases Stefan mentioned, Klaus Zieschang and Elisabeth Käsemann, and therefore we focused very much on that and argued. We've kind of hoped that these cases can serve as, let's say, locomotives of all the other work, which to some extent was true. It would be negligent to not mention another set of cases which have not particularly been embraced by the Coalition Against Impunity from the very beginning, and that are the cases against Mercedes-Benz because of the disappearance of the trade unionists at Mercedes-Benz. So this was supported by parts, and then later on, when the German-Argentinian mothers would express their support for the cases, the coalition also joined. But it shows also that we were not in everything the same opinion. We discussed a lot. We had to discuss a lot because this was a new territory for all of us. And so the Mercedes-Benz case was also investigated by the German prosecutor, but with a lot of reluctance, and they were put on hold for two reasons. One, it was the same reason as with the other cases where we had no dead corpses. So the workers who disappeared from the Mercedes-Benz plant were only disappeared, and so under the perspective of the prosecutor, we couldn't prove homicide. And then they would also argue that the main testimony of one torture survivor contained contradictions. So that was more or less the kind of cases. And then what happened after 2003 was the 2004 application in Germany. They argued for the extradition of Videla and Massera from Argentina, and then slowly the Argentinian cases were reopened, and I assume that others will talk about that. But I come back again to our efforts in the Kibo case. So what we had in mind was, now with the, let's say, all the experience of 25 years, was not only to bring the family members and other witnesses from Argentina to Germany and testify about the magnitude of the crimes committed in Argentina. It was not only to work as professional lawyers and civil parties in the oral hearing, but we also wanted to contextualize the cases, because criminal cases always run into the danger to individualize the crimes, much more complex crimes, which wouldn't have been possible without a state apparatus behind it. And so, and also criminal cases in most cases are not appropriate to tackle the root causes of the crime. So what we had in mind was obviously to embed the criminal cases into a larger narrative on the role of the Western countries in the Cold War, allying with military dictatorships all over the globe, and selling it as efforts of democracy against the communist enemy. And the other thing was definitely what we would have and might also on a lower scale now bring on the agenda is the role of economic actors. Some efforts have been done in Argentina since then. I remind you of the Ford case, but also the Mercedes-Benz case, which will hopefully, if the government doesn't intervene, will be on trial in the province of Argentina. That's the criminal case against Juan Tasselkraut, also now 25 years old. And last but not least, what is important for this kind of work, we start somewhere to denounce the crimes of the dictatorship, but our obligation is also to remind us and others that the fatal decisions of that time last until now. And I only mention the foreign debts, which are Argentina, which are overburdening Argentina, and which are one of the root causes of the deep economic crisis, which brought the fascist Milei, but also his incredible, dangerous vice president to power, a person who dedicates her work since many years to to revise the incredible work of the Argentinian human rights movement on one hand, but also the very important work of the Argentinian justice system on the other hand. And so that's something where, despite discussing the legal details of the cases of the past, I see as our particular task, those of us who have an insight of what's going on in Argentina, it will be incredibly important to support our colleagues, the human rights movement, as well as the jurists and the justice system in Argentina to maintain their work on these cases. So that's from my side. Thank you very much.
Thank you very much. I would like to remember you all, if you want to make any question, the chat is open for that. So you can write them there in Spanish or English. Now we have first a comment that you have already talked about, Wolfgang, that is about the new government in Argentina. We don't know what is going to happen so far. But we have another question from Daniel Stahl. He says, Wolfgang Kalek, you mentioned that the Argentine familiares de desaparecidos were not entirely happy with the homicide lawsuit. Could you go into more detail about how different German and Argentinian legal ideas and traditions shaped the work of the coalition? To what extent would you say that Argentinian legal debates influenced German legal debates at the time?
Yeah, thank you very much, Daniel, for this question. First of all, it is not the German legal debate and not the Argentinian legal debate. In Germany, we were some poor souls, and in Argentina, it was a little bit more. So what is interesting was that the work of the coalition against impunity wouldn't have been impossible without first the support of the family members of the disappeared and assassinated citizens and the torture survivors. So that was one important group. And the second group was the human rights movement, the different human rights organizations, from the Madres de Plaza de Mayo, Abuelas de Plaza de Mayo, Hijos, and all the other organizations. So one of our, let's say, nicest but also most difficult task was always come from Germany and face the challenges of this group. And so it was always like they accused us of not understanding what happened in Argentina, not understanding the system of forced disappearances, and so on. And then, of course, which is in a way a typical lawyer's dilemma, that you have to explain to your clients, to other stakeholders, what's the legal situation in the country. And then in every second sentence, you have to say, I'm not responsible for this law. You know, this is just as it is, and we have to deal with it. And so it went back and forth and back and forth. And so actually the reason why we filed the aforementioned complaint because of genocide was not that we were particularly convinced that this complaint will be taken by the Federal Prosecutor's Office, or also the argumentation on continuing crime in the case of disappearances, but it was in a way to also kind of balance the desires of our Argentinian friends and colleagues, and also make it visible where the gaps of the German law are. So it was a very particular debate between some groups in Argentina and us, and not necessarily a legal debate on that high level as you might assume, Daniel, from your question.
Thank you very much. I see we have no more questions, and due to the time that we are a little behind, Boris, I would like to give the word to you in order to make our break.
Okay, so thank you very much. Of course, first and foremost to Natalia, Wolfgang, and Mr. Herbst, Stefan Herbst, for their contributions and for moderating the first panel. So as you have seen, we have thought that it might be a good idea to have a short break between our first and our second sessions to get some coffee or fresh air, just stretch our legs. So I think we will resume our second panel maybe at 3:25. So we have 10 minutes break. Dorothea, I'm looking at you. Is that okay? So thank you for your participation, and see you in 10 minutes. 3:25. Until then. Back with us here. Welcome back, everybody. As mentioned before, in our second session, we would like to shift our perspective more to the present and the contextualization of the efforts of the Koalition gegen Straflosigkeit some 20 years ago, with later developments. Some things have already mentioned before by Wolfgang Kahlig. The Louis Kieburg case will be one of the things we will discuss, and I'm sure we will add more in the following 50 minutes. The chair of our second panel will be Stefanie Bock. Stefanie Bock is a dear colleague of mine at Philipps Universität in Marburg. She's a professor of criminal law, European and international criminal law, and comparative law. She's also the director of the International Research and Documentation Center for War Crimes Trials, ICWC, and a member of the Memoria-Legal Working Group of the Elisabeth Käsemann Foundation. So, and with this, Stefanie, I hand over moderating duties to you, please.
Thank you, dear Boris. It's a great pleasure for me to be here today to chair a panel of this very interesting and fascinating conference. So, much to my regret, we will probably have a little shorter but not less interesting second panel, because one of our speakers, Federico Efron, had urgent duties and had to cancel his participation in our conference on very short notice. He will try his very, very best to join us later. We will see. I will have always a view on our list of participants. But very, very, very great thanks to Alberto Zuppi, who also decided on very short notice that he will jump in and give us a short input with a particular view on the Käsemann case. It's not much sense of introducing Alberto Zuppi to you, because I assume that he's already very well known to everyone. But let me at least summarize, give you a short idea. He's a former Robert and Pamela Martin Professor of Law at the Louisiana State University. He has a broad expertise in various subjects, but in particular on international criminal law and public international law. And in so far, he's not only working on this subject from a theoretical academic perspective, but also with a very close cooperation with the practice. And so, Alberto, we are very much looking forward to your insight, and thank you so much that you are willing to fill our gap with your input. Thank you so much.
Thank you, Stephanie, for those fine words. As a matter of fact, I don't know if you can recollect what happened with Argentina human rights during those years, but it was a long, long fight, even to recognize principles that they were accepted by all the world around. For instance, I think that the first step in that direction was already given in 1987 when a Nazi was extradited to Germany, Joseph Schwamberger, because the case had several aspects very interesting for international law. As a matter of fact, one of the things was the statute of limitations. Germany has considered several prorogations of the statute of limitations, but the crime was a crime against humanity, and in order to convince the Argentine justice that crimes against humanity are not subject to statute of limitation, let me tell you that it was a great, great fight. The second step, perhaps, was also the extradition of another Nazi from Argentina. That was the case of Erich Priebke in 1994. In addition to that, it was the problem that Italy had requested extradition based on the charges of war crimes. And as you know, as a requisite of any extradition, we require the double criminality, and war crimes were not included in our criminal code. And it was certainly a problem because that will be the case of somebody who is going to be extradited for a crime that was not included in the criminal code, and we follow the German system of typus. I mean, we need to have a specific crime in the code in order to configure a criminal conduct. Well, thanks to the case of Priebke, the Supreme Court in Argentina recognized the existence of crimes against humanity as something that was obliged under international law and was not requested to follow the criminal code. In 2001, that was an incredible year in Argentine history and a year of turmoil and problems. In December 2001, I had the honor of representing the German government in Argentina in the extradition case of because the abduction, torture, and murder of Elizabeth Kesselman. And well, I as expected, because that was not a question of legal theory, but political decisions. The extradition was refused by the Argentine judiciary based in those two laws that we have already mentioned, the full stop law and the due obedience law. Then I recall that I had a meeting with the German Chancellor Gerhard Schröder in Buenos Aires, and he authorized me to go so far as possible. And when we received the notice of the denial of the extradition, Germany made an unprecedented step of appealing that denial. I mean, it is not normal. You must understand that the extradition proceeding it is very engaged with diplomatic matters. And as a matter of fact, it is something that the consul of Germany sent to the Argentine Ministry of Foreign Affairs, and then it was resolved in those between those entities. But the problem here was that there was a strong convincement of Germany of going further in this case, and I think that I don't know of any other case where one government refused an extradition and the requesting government appealed that decision before the Supreme Court of the requested government. That was certainly, in my opinion, unprecedented, and perhaps was also surrealistic and unprecedented too, that the appealing was based in violation of Argentina, not only of international law, with two laws, the final full stop law and the due obedience law, that they were violating all international standards, but also internal law, because the menem's pardons, they were against our own legal system, because in order to be pardoned, you need to be prosecuted and condemned. And the militaries were not either prosecuted or condemned. Then in a very strange way, Germany was teaching law to the Argentine government, not only international law, but Argentine law. Well, let me add a note of color, if you wish, of those strange days. In December 16 of 2001, I introduced the appeal to the Supreme Court, a direct appeal to the Supreme Court of the denial of the extradition. At the same time, I was representing in Argentina the victims of the AMIA case. I don't know if you know about the AMIA case, but it was a very important case in Argentina during several years. There was an attack against one Jewish institution, killing 86 people and injuring hundreds. And it was very clear from the beginning that Argentina was not doing, and certainly the judge was not doing something important in order to investigate the case. Because the pressure exercised by the community and the victims, we have finally obtained, after several problems, we need to go to the Inter-American Court of Inter-American Commission of Human Rights, and then we began a proceeding against Argentina before the Inter-American Commission of Human Rights, and we obtained a conciliatory solution that we will postpone to follow our claim until an oral trial in the AMIA case was going to be to take place in Buenos Aires. The point is that everything happened in the same moment and in the same building in Comodoro P, in the federal criminal judiciary had their site. And well, I'm mentioning this because the AMIA case gave us a lot of press support. We made press comments every day. We have the television on our side, the radio, and the press, because certainly we were representing the victims. And in that day, December 16, when I introduced the appeal and the Keseman case, I used the same press and media in order to obtain all attention about what Germany was going to do. And it was very interesting. I say that there is a principle of international law that it is very well known under a Latin phrase, audedere aut judicare, that means you prosecute or you will extradite. I mean, giving the option to prosecute somebody who is requested or to extradite to somebody who requests the extradition. And Argentina was denying that principle of international law. Then I declare that Argentina was doing this, and that was against the formal basis of international law. But I say that it was a colored note because on 21 of December 2001, the Argentine president resigned, and a new government was elected, and the new president selected me as Ministry of Justice. Then the same press that was, I request help in December 16, asking for, well, listen, Argentina is violating international law. Then they came to me and they say, yeah, now what? And certainly I said that I was convinced to continue with that idea, and that my comments on that subject was perhaps the only critical point of that very short government of Rodriguez Sá, a president who just existed as such for just 10 days. But in those 10 days that they were very intense, we have the only problem in the cabinet because my comments, and I was summoned to a meeting with all three commanders-in-chief and the president in order to explain the principle of audere audicaria. And well, I did so, and the decision was to establish a commission. And as it is very well known, if you decide to establish a commission, that means that the subject is going to be forgotten. In any case, in 2005, the Supreme Court refused our appeal on the grounds that they were not, that I was not appealing a judgment on extradition, but a simple decision of the Ministry of Foreign Affairs. And well, that was in the meantime not very important because for that time already Argentina had declared null and void the two laws, the full stop law and the due obedience law. And as you know, all the proceedings against the military began being prosecuted here based on the subject, on the principle of territoriality. Then let me just, as an improvised speaker for this meeting, add these few comments with a note of color to tell you about what happened in those turbulent times. And I'm certainly very open to any questions that you may have to this matter. Thank you very much.
Thank you, dear Alberto. Although I have to say it was not an improvised statement, but rather a full-fledged speech. So thank you so much. Now I have the great pleasure to turn over to our next speaker, also as Alberto, a member of our Memoria group of the Elisabeth Kissmann Stiftung, Julia Genois. Julia is a dear colleague of mine. She's professor for German and international criminal law, criminal procedural law, and comparative law at the University of Bremen. She has a particular focus on the prosecution of international crimes in Germany. She did her PhD on the question of discretion of the prosecutorial service in Germany, and this was her focus. And now I see Federico made it. Great to have you here. So we will have not only Alberto's more or less improvised, but was a full additional statement, but also Julia and Federico's statements as announced. So Julia, without further ado, the floor is all yours.
Thank you very much, Stephanie. Yes, I'm very, very happy to give a short input in this first event of the Memoria Talk series, and I'm also happy to see so many participants. So a warm welcome also from me. So what I would like to do in this brief input is to, as Boris already mentioned, to look into the future, to look into what happened after the Videla arrest warrants. And so I would like to just very briefly present what happened in Germany in the last 20 years, so to say. So as Wolfgang Kalek already mentioned, when we planned this event, we thought that it would be a very good idea and very fitting to take the case against Luis Esteban Kaiburg or Keyburg as a starting point to sketch out this development, because it's again a German criminal case dealing with crimes committed during the Argentinian dictatorship. And it was and still is a very important and timely case, and Wolfgang said that the indictment against Kaiburg just has been filed before the Berlin Regional Criminal Court earlier this month. But then, as things happen, Luis Esteban Kaiburg died 6 weeks ago, so the case was terminated. There is no Kaiburg case anymore. But still, the case serves as a good point of reference, we thought. So I will very briefly in the next minutes present the case against Kaiburg, and then I will very roughly try to situate the case and the proceedings in like a broader development of criminal cases for crimes under international law in Germany. And there we can see that there's kind of like 2 dimensions where we can kind of situate this case. So the first one is linked to the entry into force of the German Code of Crimes Against International Law, so the Völkerstrafgesetzbuch in German, also 20 years ago, and then the ensuing practice and the current practice regarding these international crimes, a development that can roughly be regarded as quite successful. But then there is a second dimension where we can situate the Kaiburg case, and that concerns international crimes committed in Latin America by alleged perpetrators with a German passport who, like Kaiburg, fled to Germany and therefore could not be extradited. And these kind of set of cases is maybe less of a success story, as we will see. And here the Kaiburg case actually stands out from this set of cases. So first, very briefly on the Kaiburg case. So Luis Esteban Kaiburg was born in 1948, and he was the deputy commander of an elite tactical divers unit, and later the head of the Department of Personnel Operations and Logistics in the Argentine Navy at the military base in Mar del Plata in 1976. And it was later proven by an Argentinian court that at that time over hundreds of victims were kidnapped and tortured and murdered and disappeared at that naval base. And for these crimes, Kaiburg's colleagues were convicted in the so-called mega causa Base Naval by an Argentinian court in 2016, if I'm not mistaken, and they were sentenced to high prison sentences. But Kaiburg fled to Germany already in 2013, at the point when he was summoned to testify in Argentina, and he fled in order to avoid prosecution. Then the Argentinian authorities issued an international arrest warrant for crimes against humanity, and then sought his extradition in 2015 from Germany. But due to Kaiburg's German citizenship, it was constitutionally impossible for German authorities to extradite him to Argentina. And instead, the German public prosecutor in Berlin opened an investigation against Kaiburg on the suspicion of murder. That's what we already heard from Wolfgang. And he also mentioned that in German criminal law, crimes against humanity were only implemented in 2002. I will briefly come back to that, by the German Code of Crimes Against International Law. And due to the principle of retroactivity, because the crimes were committed in the mid-1970s, actually murder was the only crime applicable in the case. All the other crimes were already prescribed. And maybe just as a side note also, German criminal law does still not know the crime of enforced disappearance as an ordinary crime. We have enforced disappearance as a crime against humanity, but not, at least not yet, as an ordinary crime. But there actually is a current draft bill to finally introduce the crime of enforced disappearance. And then these German criminal proceedings in the Kaiburg case became more pressing after an Argentinian journalist actually located his house in Berlin. And after that, also relatives of the victims, with support of the ECCHR, we heard that from Wolfgang, and still as part of the Coalition Against Impunity, filed a complaint in Germany. And then there were actually intensive investigations by the Berlin prosecutor, and with some delay due to the pandemic, the prosecutor filed the 220-page indictment at the Berlin Regional Court at the beginning of this month for murder in 23 cases. But then, as Wolfgang said, around 10 days ago, it became known that Kaiburg had died already in mid-October at the age of 75. So the case was terminated, the proceedings were terminated, and the case is gone. So what I will now very briefly do is to say a few words about, as I said, the context in which this Kaiburg case took place, explicitly from the German perspective. So from the German perspective, as I mentioned, the case can be situated into the development of the prosecution of international crimes in Germany in two perspectives. First, into the broader perspective of, so to say, of German international criminal law more general, but then from a second perspective, within these efforts of civil society organizations of bringing those German citizens to justice who fled their trials or the enforcement of their punishment in Latin America, namely in Argentina and Chile, and came to Germany knowing that they could not be extradited. So first, regarding the this broader development of German criminal law, what has happened in the last 20 years. So in 2002, so at the same time, the arrest warrants against Videla and others were issued, the German Code of Crimes Against International Law entered into force in Germany. And the code contains crimes under international law, so genocide, crimes against humanity, war crimes, and the crime of aggression, and transposes them into the German criminal law system. And one of its most important features, I would say, is that the code also subjects these crimes, with the exception of the crime of aggression, under the principle of absolute universal jurisdiction. So these crimes under international law, can be investigated and prosecuted in Germany, no matter where, by whom, and against whom these crimes have been committed. But as I said, in 2002, the code entered into force, and in the first 10 years or so after the entry into force, the code was actually not applied or enforced. But this changed around 2010 with the development, with two developments, actually a factual one, that is the conflict and the atrocities committed in Syria, and the ensuing migration movement. So a lot of victims of these atrocities, but also perpetrators, came to Germany, and then there was this started a development and a number of cases regarding this conflict situation. And then as a legal development, we had this instrument, I would say, of the so-called structural investigations, so that the German federal prosecutor general, who is competent to prosecute these crimes, first looks at the situation in general, gathers evidence, and then as a second step looks at specific suspects. So as of today, the situation is rather, so to say, there has been a good development regarding German international criminal law practice. So we have roughly a high double-digit number of court judgments so far regarding cases dealing with international crimes committed abroad, in particular regarding the situation in Syria and in northern Iraq. But there are also there are a few, like, actually the most important case, so to say, is also from that conflict situation, but against members of the Syrian intelligence service, so against members of the state authority. Most of the other cases are against members of non-state armed groups, but we also have these important cases against members of the state regime, so to say. So I would say that although there is enough room for criticism, roughly speaking, it could be said that the development in this regard regarding German international criminal law is not half bad. And from this perspective, one could say that the arrest warrants against Videla and others, and then 20 years later, also the Kaibo case, can be regarded as a starting point and as part of this rather successful development of German international criminal law, and that actually in both of these cases, the German authorities tried to do their part in this global effort to investigate and prosecute international crimes. But as I already mentioned, there is also like a second perspective to look at the Kaibo case that needs to be taken into account to complement this picture. And that is the perspective of alleged perpetrators with German citizenship that fled to Germany to avoid prosecution in the countries where the crimes were committed and could not be extradited because of their German citizenship. So because they could not be extradited, the only avenue to bring them to justice is to prosecute and try them before a German court, or to enforce their sentence in Germany. And I don't want to go into detail because we don't have a lot of time. I just want to mention that there is a very important case, a case from Chile concerning crimes that were committed in famous Colonia Dignidad, so a German colony, kind of a sect, where the leader, Paul Schäfer, was convicted for child abuse. And this leadership also cooperated with the DINA and so Pinochet's secret service. And one of the close friends of Schäfer, the leader of this group, Hartmut Hopp, he was actually convicted in Chile for aiding and abetting sexual abuse of minors. And before he could be imprisoned in Chile, he fled to Germany in 2011. Chile sought extradition. extradition was denied because of his German citizenship. And then also the enforcement of the Chilean sentence was denied by a German court. So there also were some investigations in Germany against Top, but I think it's fair to say that these investigations were not conducted as effective as those against Kyborg, and they were finally terminated in 2019. And there are a few other cases very similar, also no German trials, no extradition, no enforcement of foreign sentences in Germany. So I just mentioned this to say that from that perspective, actually the Kyborg case stands out as an exception, and it of course would have been very interesting and important to see this case tried before a German criminal court, but due to the death of Kyborg, unfortunately, it has not come to that. So I leave it at that. Thank you, and I'm looking forward to Federico's presentation and the discussion.
Thank you very much, dear Julia, for this insightful German perspective. And now I have a quick look at Federico. Are you still willing to give your presentation?
Yes, hello. Do you listen to me properly?
Yeah, great, we can hear you.
Okay.
So, excellent, so great to have you here. Just a few sentences to Federico Efron. He is specialized in criminal law and human rights. He is National Director of National Legal Affairs and Human Rights Secretary, Ministry of Justice. And he is working with a team of 16 professionals, mostly lawyers, working as a trial of crimes against humanity committed by the last military dictatorship. So I could not imagine somebody who's better situated to give us an insight into the Argentinian perspective. But Federico, as we are a little bit behind our schedule, I would like to ask you to respect the time frame. So, but now,
okay, so can you give me a minute, please? I am sorry. I'm sorry for the convenience. At this moment, I'm in an office. I don't know where, somewhere in the building of the Ministry of Foreign Affairs. I have to replace the Human Rights Secretariat at an award event for a South African NGO. It was a beautiful moment, but I didn't plan to be a part, especially welcoming everyone. But I'm glad to be here, and I am really sorry for the inconvenience that I created with this delay. But I'm here, and I want to talk about the Arancibia Clavel case. Is it possible to share screen for a few minutes? It says like
David, I get the question goes to you because I think I don't have the rights to. Yeah, okay, you should be able to.
Okay, yeah, I see this now. So, do you see the presentation of the Arancibia Clavel case? Okay, thank you very much. So, the key issues I want to address today, shortly, because I know we have only a little time. First, who was Arancibia Clavel? The main facts of the case, the ones we need to know to understand what are the legal discussions and what was that the Supreme Court of Argentina ruled in 2004. And then I would say only a few comments on the impact it has since then, because there's a lot to say. And then I'm open to anything you might need additionally, of course. Arancibia Clavel was actually a citizen from Chile. He was a spy. And from 1974 to 1978, he, as a member of DINA, the National Intelligence Directorate of Chile, was in Buenos Aires collecting information as a part of the persecution of political opponents to the regime of Pinochet in Chile. In this organization, he created a network of informants, and he was not only looking for them, but he was also participating in different moments where they kidnapped the people or they were tortured. He used the information, the personal information, to disguise his own identity. He was involved in what we know is the Latin American dictatorships. In Argentina was from 1976 to 1983. From Chile, it was larger, and they were all connected, not only under the same view of these dictators, but also they were connected within the Plan Condor, who was actually established, and it was recognized in different rulings in Argentina years later than this particular case, the case of Arancibia Clavel. The facts of the case. Arancibia Clavel was a Chilean spy. He was on trial, and he was convicted to prison for life for the crimes of conspiracy or illicit association. In our penal code, it's illicit association. We don't call it a conspiracy. And homicide against 2 victims. He was convicted of participating in the homicide too. The Court of Cassation, who has to review the conviction, says that the crime of conspiracy or illicit association can't be considered a crime against humanity because it wasn't in one of the different type of actions that international law, particularly the Statute of Rome, but other international conventions said it was can be a crime against humanity. And so therefore they say that the statute of limitations applies to this particular crime. So the conviction for being a member of illicit association doesn't stand. It's very interesting because it was the government from Chile who went to the Supreme Court with an extraordinary appeal, asking for the court to take the case, something that is not simple, but also to say that this can be a crime against humanity, and it cannot be considered that there's no more place for the government, for a state to prosecute someone. In Argentina, I don't know, I know in Germany too, but not all the countries, the victim can participate as a complainant victim or as a querella in Spanish, and they have almost the same capabilities as the public prosecutor. Not the same, but almost the same. And in terms of formulating an accusation that can lead to a conviction, they have the same capabilities. What we do in my office is that mainly we have 265 querellas all over Argentina. So the legal discussions that the court has to decide and rule were 2. Can the crime of conspiracy or illegal association be considered a crime against humanity? And does the statute of limitations apply to crimes against humanity? As a comment of context, this was 2004. It has begun from the first declaration of nullity of the due obedience law and the full stop law. In 2001, they were declared unconstitutional for the first time. So it has begun a process of reopening of the cases. And in 2003, with the new government, it started to become what is now a consolidated state policy. The state policy of memory, truth, and justice. So this is the context of this case. It was also with new members in court. It was a very interesting and really respectful of human rights era in our country and in our Supreme Court particularly. The court ruled 2 things. In both things, they ruled for positive in terms of respecting human rights and the truth and the right of the victims. First, they say that, of course, conspiracy or illicit association can be a crime against humanity, and given the context and the facts proven, it is clear that this is the case. The main idea was that if the illicit association was destined to persecute political opponents. There's a direct link with crimes against humanity that usually respond to political opposition, to persecution of political opposition. If you consider Article 7 of the Rome Statute, you will find that this is perfectly capable of being considered a crime against humanity. And therefore, we go to the second question, I'll go back in a minute, applies the imprescriptibility, or there's no statute of limitations. I'm gonna work only for a few seconds, because you have the main vote by the members. It's only 20 pages long, but then you have different votes by another Supreme Court judges, particularly the one from Massera. He goes lengthily on international law, human rights law, and the conventions. It analyzes lengthily this issue. It says clearly that it's not possible to dissociate the activity of those groups, or those who group together to commit crimes, from those who carry them as perpetrators. This will have a lot of impact in the next years, and it has until now in Argentina. And it also take a few pages, a few long pages, to talk about using the use of the criminal code and using the national law as part of, in a way of talking, in a way of connecting with crimes against humanity and the different international conventions. It says that in addition to being the product of the criminal policy adopted by the legislator, it says our criminal code also appears as the instrument with which the Argentine state assumes the punishment of certain conducts as required by the international community. And this has to say a lot about the decision we make as a society a few years ago. The decision was, we want to judge them here and without laws at the moment. It's due process, and this is the way the court started to solve this issue and making it play together. A lot of this has to do the reform to our constitution in 1994, where we incorporated to our constitution a lot of international human rights treatises. And also it has to do with our first constitution, or the constitution from 1860, that even from at that moment, it talked about the law of the land. That the way we from 1860, we were already saying that are certain crimes that are so heinous that offend the humanity, and we stand against them. So this is not something new. This is not something that we create to judge these kind of crimes. And this is all developed particularly in Massera's vote. Also, of course, the court already also ruled that there's no statute of limitations in Argentina regarding crimes against humanity. They already said it in Priebke a few years ago. Priebke was a Nazi who was living peacefully in Bariloche, a beautiful town in the south of Argentina. He was loved by everyone, and suddenly they found him and they wanted to extradite him. And the Supreme Court at that time in the 90s, they say that in terms of human rights violations, the crimes against humanity, there's no statute of limitation. So they confirmed that ruling, and they say, therefore, the conviction against Arcibia Cabel for the crime of illicit association and conspiracy stands. Since then, in 19 years from that, we have 336 rulings by different federal courts all over Argentina for 1,200 defendants who were convicted. Another around 180 were acquitted. With Arcibia Cabel, from those 1,200, 160 were convicted also for the crime of conspiracy or illicit association in the context of the crimes against humanity committed in the Argentina dictatorship. And they also consider part of the crimes against humanity other crimes other than homicide, and forced disappearance, or rape, or torture, theft, extortion, breach of duties of a political official, or prevaricate in the cases of the judges who received the habeas corpus and didn't investigate when they have a lot of information too. And one comment I would like to make regarding the we have oral trials in Argentina, but the ruling is written, although they read it in an oral hearing, is written, and you will find that the first point always says, 1, stating that the facts proven in this case constitute crimes against humanity, and then they go 2, to convict some guy to the crime of this is really it's part of the evolution of the judgment in Argentina of the crimes against humanity in the last 20 years. And a small comment to end. Last year, we have a truth trial for an indigenous massacre that occurred in Argentina in 1924. And they say that there's no statute of limitations. There's a crimes against humanity. We have our constitution from 1860 that talks about the law of the land. And it also cited, quoted numerously, the Aracida Clavel case too. The impact has been enormous. It's not the only one of the only ruling by the Supreme Court in those days, but is clearly one of the most important. In Argentina, we are facing the assumption of a new government that is probably gonna try to change everything. This is one of the things that we have to defend, and we'll see how it goes. Thank you very much. I hope my English is good enough to make myself clear, and I try to make it up really quickly. Thank you, and whatever questions or comments I'm open to. Thank you.
Thank you very much for this interesting and very clear presentation, Federico. And we have the first question in the chat. The question goes to Julia. Do you see an evolution in the handling of cases by German authorities in cases of German citizens or citizens, I would like to add, of any nation fleeing in Germany in order to avoid prosecution, or were the differences you mentioned in the cases due to factual or juridical differences between the cases?
Yes, thank you for this question, difficult question to answer. Well, I'm not sure. I think I would like to say that there is some sort of evolution, but I think when you look at the timeline, it's not becoming clear, because the Colonia Dignidad case against Hartmut Topp, it was terminated in 2019. So also at a time where kind of the importance of German international criminal law and of these kind of cases was very was strong in Germany, at least. So I'm not sure if there is really an evolution. The cases are different, of course. So the legal the legal facts, or the facts and the legal assessment of these cases is different. But I think it also at least comes back to individual people dealing with these kind of cases. And I think in the Berlin case and the Kaiburg case, the Berlin prosecution understood the importance of the case and was kind of interested and effective in gathering evidence. I think this is not, and I think it's not unfair to say that this is not the case in the when it comes to the prosecution office who dealt with the Hartmut Topp case and the Colonia Dignidad case. I think they were less effective, so to say, and they kind of kept a very narrow look at the case itself and only looked at the facts that were, or only looked at the case that the Chilean courts dealt with, although it would have been possible for them to, to broaden the perspective and look at the Colonia Dignidad issue in a broader sense. And they did not do that, and they could have done that. And I think that's a severe criticism that one can make regarding this case. So I guess, so I don't know, but my feeling is that the Kaibo case would also have been important for this set of cases to have a positive example that could then maybe lead to other efforts in similar cases.
Thank you very much. Just got a hint from Boris that he might have something to add or additional question he didn't dare to post in this chat. So I give the floor back to our main moderator.
Thank you, Steffi. Maybe it's just because, of course, it's a great pleasure to have you, Claudia. And just to add maybe one detail, not with regard to the cases that we are now thinking about, but maybe from even like cases dating back to the Nazi crimes, because there, of course, we also had these problems with Germans. So in some cases, maybe even citizens from other countries who, because of their services to the SS, then became German citizens, or at least it was in question whether they got the German citizenship during the Nazi years. So I would say that in these cases, at least, we had some developments in the efforts, and even to some extent with how it was dealt with some legal problems, because there we had cases for most notably the Böhre case, but also the Ziad Bruns case. So both citizens originally coming from the Netherlands and that were tried in absentia, or in the Böhre case, he fled before the sentence had been executed to Germany, and there, if I remember correctly, the German prosecution dealt with these cases differently in the 2000, the first decades of the 21st century than before, because they didn't stick to, for example, the very strict application of the nebis in idem principle in these trials in absentia, as far as I remember. So, for example, there we can see a certain development at least. But of course, that was not exactly the cases you were thinking about.
Thank you. And another question goes to Julia. On the difference between enforced disappearance as a crime against humanity and enforced disappearances as an ordinary crime, could you please, with a view to the clock, could you please give a short answer on the difference?
Yes, so I will try to be very brief. So we have enforced disappearances as one of the many individual crimes as crime against humanity. So, for example, murder is also a crime against humanity if this murder is committed as part of a systematic or widespread attack against the civilian population. And the same is true for enforced disappearance. In Germany, in the Code of Crimes Against International Law, we have crimes against humanity, and one individual crime of this crime against humanity is enforced disappearance. So if there is kind of a policy of enforced disappearance as part of a systematic or widespread attack against the civilian population, it is a crime in Germany. But it is not a crime if you only have like singular incidents of enforced disappearance, or if you cannot prove this kind of systematic policy, then enforced disappearance is not a crime in Germany. So we don't have it in the like regular criminal code as a crime, but only as a crime against humanity in the Court of Crimes Against International Law. But as I said, and I just want to emphasize this again, there is a new draft code or a new draft law where specifically also it is planned to introduce this crime of enforced disappearance into the ordinary German criminal code, also because Germany is under the obligation to do so under the International Convention against enforced disappearances, which was ratified, I think, in 2009, but up until today, Germany has not done so. And this convention also knows this difference between enforced disappearance, crime against humanity, and as ordinary crime. So this very roughly is this distinction. Thank you.
Thank you very much, dear Julia. And thank you very much to my three speakers of the second panel. It was a real pleasure to listen to you. I've learned a lot this afternoon. And then I give the word back, I guess, to Boris for the conclusion of the awards setting, or to Dorothy.
Yes, I guess so. We can both close up, Boris, but it is my pleasure to look back on this very successful event already now. We try to post it on YouTube as well to have a look on it and hear it again. And I would like to thank very much to Alberto, express my thanks to Alberto for this very important historical review. Good to have it, that we had it. And especially thanks to Federico Efron that he could make it in his tight agenda and schedule to present his very interesting and instructive lecture. I would like to thank you as well, our auditorium. I hope we will see you in our next second Memoria Talk as well. And well, please have all a good rest of the day, nice evening in Germany, and thank you very much.
Bye-bye. Thank you for the invitation.
Bye-bye.